United States v. Miller out of the 11th Circuit. It's a Sentence Enhancement Armed Career Criminal Act case. It's important because it's about the categorical approach, which also applies in immigration, crimmigration. But more importantly, the 11th Circuit just held that Florida's definition of cocaine is broader than the federal definition during certain years. But honestly, this follows, and I said it on the podcast when the Supreme Court ruled, this follows the Supreme Court's Brown decision last year. Justice Alito, of all people, was pontificating in the Brown decision about how in 2015, Congress stopped listing a cocaine derivative that was used in Parkinson's disease research. But the states didn't follow suit, or at least most states didn't follow suit. So there was a time, it seems, a certain point in 2015 and a certain point in 2017 in Florida where the drug is called ioflopane. It's a derivative of cocaine, I guess a kind of cocaine. It's used in Parkinson's research. There was a time between 2015 and 2017 where the federal government didn't list ioflopane as a controlled substance, but Florida did. That Florida's definition of cocaine was overbroad. 11th Circuit said, yeah, that's not divisible. So Florida cocaine, not a controlled substance that makes you removable from some date in 2015 that I don't know until July 2017. There wasn't a match. Now, the 11th Circuit says, oh, what are you comparing it to? You're comparing it to the federal schedule and the state, it would appear, at the time of commission or conviction. I'm not 100%, it's a complicated decision. Point is, someone in removal proceedings today, and other case law is making this quite clear, someone in removal proceedings today who had a cocaine possession conviction from Florida from 2016, I'd bet the farm that person's not removable. And especially in the 11th Circuit, the United States v. Miller. But really, it's relying on the Supreme Court's Brown decision from last year and Justice Alito making quite clear all of this. So Florida cocaine, and probably not just Florida cocaine, probably a lot of states that were still criminalizing the derivative ioflupane in between periods. Oh, I could keep going on and on. The BIA would have you believe that for the isomer argument, which is distinct from the derivative argument, derivatives and isomers are different, that you have to find a case. That's a matter of whatever it is. But like even that is not good law anywhere except the Fifth Circuit. But more to the point, both the Supreme Court and the 11th Circuit have said quite clear, ioflupane exists. And it appears there might have been convictions for people possessing ioflupane before it was not listed anymore. So this is a big deal. So Florida, 2-year period, but who knows? Maybe your state still criminalizes possession of the cocaine derivative ioflupane, meaning possession of cocaine in your state. It's not a removable offense.